Hi, my name is Kevin O'Shea. I'm an intellectual property attorney with the law firm of Weiss Miller in Chicago. I assist clients in matters involving intellectual property, which is to say patents, trademarks, copyrights, domain names, and trade secrets. We assist our clients both at the beginning when trying to obtain a patent or a trademark, for example, and at the other end of it when there's potentially a dispute. Either someone is asserting a patent against one of our clients or our client needs to enforce their patents or trademarks or copyrights. My goal today is to give you a very broad overview of issues that you should be thinking about and talking to your team about in intellectual property matters. Each of these specific areas is complicated. There's a lot of issues. Every company is going to have different issues that are specific to the company and industry. So again, my goal is to be fairly broad about it and then at least give you the ideas that you should be thinking about, and then you can go from there to focus in on issues that are specific to you or areas that you may want to know more about. So again, what is intellectual property? Well, there are generally 5 types. There's patents, there are trademarks, there are copyrights, trade secrets, and domain names. We're going to go through each of these individually. And I know maybe the idea of domain names doesn't typically come up in an intellectual property discussion, but today it is an important part of a company's intellectual property. So let's start with patents. What is a patent? A patent, literally speaking, is a government monopoly that allows the patent owner to exclude someone else, all others, from making, using, selling, importing, and or offering for sale whatever is covered by the patent. Now, the patent, for example, as I've set forth here, could be a mechanical or electrical machine. It could be a process or a business method, the method by which you do things. For example, I've represented clients where their sourcing methods were covered by a patent or even a trade secret. You can also get a patent on an ornamental design. That's the non-functional aspects of a given product. How do you get a patent? Well, you have to file a patent application with the U.S. Patent and Trademark Office. Your idea, your invention, has to be new, useful, and non-obvious. Now, it's very easy to say. There's hundreds of years of case law describing what exactly is new, what's non-obvious, and what is useful. And it changes constantly. So this is a very complicated area, but the basic idea is that in order to be a patentable invention, the process or machine has to be new, useful, and non-obvious. If you think that you have that and you want to protect that invention and not let others practice the invention, then a patent may be the way to go. Most importantly though, a patent does not give you the right to do anything. It does not give you the right to make or sell or import anything. So others may have patents on inventions that are very close and very similar to your discovery. For example, your smartphone has thousands of patents involved. What you need to do when you are considering a patent and whether to try and go through the process of obtaining a patent, look at what's out there. Look on the Patent and Trademark Office websites. Do some searching. Talk to a patent attorney such as me or others who can help you decide whether getting a patent is the right way to go. The next form of intellectual property are trademarks. What's a trademark? A trademark or a service mark is a word, a symbol, a design, something that consumers link in their minds to a product for a trademark or a service for service marks. So for example, what are some ideas? Well, here I've put forward some basic examples. We all know them well. There's Xerox, McDonald's, Coke, Ford, Google, Facebook. These were all extraordinarily famous. We all know them. Everyone in the world knows these trademarks. But each one of them, as you read or heard me say these terms, you associated those with a particular product or service. For example, Xerox has both copiers and copy services. McDonald's, of course, is a quick service restaurant. Coke is Coca-Cola, Ford, etc. And that's the key to trademarks. You link, as a consumer, you link the term in your mind to the source of the goods. When I think of Ford cars or Caterpillar equipment, I think of who makes that. And I have a positive, hopefully, association between Ford or Caterpillar, let's say, on the one hand, and their equipment on the other. So a trademark associates in a consumer's mind the mark and the product or service. That way, competitors, you are able to stop your competitors from getting too close to you and confusing consumers into believing that the competitor's goods or services may indeed be yours. And in that way, you can stop competitors from taking your goodwill that you've built up over years in your product, your services. Now, trademark rights, unlike patent rights come from the actual issuance of a patent by the Patent and Trademark Office. Trademark rights, on the other hand, derive from you using the trademark. So if you associate your trademark with goods out on the market or services through advertising, sales, then you have trademark rights. You can register your trademark, and it's a good idea to do so because you have certain advantages by registering a trademark with the U.S. Trademark Office, but it's not necessary to enforce it. So you can have unregistered trademarks and still enforce them in court. That's not the truth. That's not particularly the same thing for patents. Finally, if you are thinking about a trademark and you've come up with a new product or a new service or maybe a sub-product within a family, take the time to perform a trademark search. This is an area that is very, very important, and you need to do the trademark search, because if you don't, and you're infringing on someone else's trademark or too close to someone else's trademark, you're going to end up in litigation. Litigation is risky, it's expensive, and if you do your work at the beginning end rather than at the end, you'll save yourself a lot of money and a lot of grief. In developing a trademark or a brand, it's very important to press your design team, your creative folks, come up with something new. Xerox is an excellent example. The term Xerox doesn't exist in the world except in connection with Xerox. So that's a great trademark because people associate it with one thing and one thing only. Now, I know it's hard to develop a brand around a brand new non-descriptive word like Xerox. Or Caterpillar even has put in obviously significant amounts of effort. When you hear the term Caterpillar, you think of just the one thing. It's important to make the best effort at the beginning that you can to get to that point where you've come up with a creative, fairly new word that, while it may take some effort at the beginning to develop the association for consumers, it's very worthwhile because strong terms like Xerox, there's only one thing you think of there. You don't have to distinguish yourself from others. Next, let's talk about copyrights. What is a copyright as opposed to a trademark or a patent? Now, copyrights and trademarks oftentimes get confused. Trademarks, again, are marks or symbols that are associated in a consumer's mind with a product or a service. Copyright, on the other hand, is any what we call original work of authorship. That's the legal term. Now, what does that mean? That means anything. It could be literary work, dramatic work, artistic works, musical works, of course, any work that has been reduced to a tangible medium. In other words, it can't just be in your head. You've got to write it down, you've got to save it on your computer drive. It's got to be in a tangible medium. But a copyright isn't just for movies and music. It's everything. It's the notes you took in school. It's your employee manual. It's your advertising and marketing materials. As long as it is a new work of authorship that has been reduced to a tangible medium, then you have copyrights in it. Now, that's important because, for example, let's say you have an employee who leaves, starts his or her own company, and maybe competes with you, and they take some of your marketing materials, or your advertising materials, or your employee handbook. or the instructions for your product that get delivered with your product. All of those may be subject to copyright, and you may be able to stop that former employee, now competitor, from using those materials. And copyright litigation is in federal court, and it gives you significant remedies that may not be available in other arenas. So all of these have copyright associated with them, and you have an ability to stop others from using it. And so it's an important issue. And again, it's not just the movies and the plays and the music, it's actually everything that gets reduced to a tangible medium. Again, like trademarks, you don't have to register your copyright with the U.S. Copyright Office. There are significant advantages to doing so, and it's not a particularly difficult or expensive process. So it's a good thing to do. But on the other hand, because copyright is so broad and there are so many types of works that can be subject to copyright, it's certainly understandable that many companies choose not to register everything. But it's something to think about as you're developing your marketing materials, your employee handbooks, things like this. You may want to register them with the Copyright Office, because if you have registered them, you have significantly greater remedies available to you in court if you ever do have to enforce them than if you had not registered them. So something to think about with respect to copyrights. Finally, with copyrights, an important point on your website, your advertising materials, all of your materials, don't infringe someone else's copyright. Don't grab that stock photo. Don't take a photo from somebody else's website that you think is really interesting and slap it up on your website. That could be copyright infringement. Don't use fonts that are not licensed. Fonts are an interesting area of copyright. If you come up with a new product and you've chosen your name, you've chosen your trademark, and you've decided you want to do it in an interesting new font, make sure you get a license to that font. Those fonts are copyrighted. It's not hard. It's all available out there. The licensing is fairly straightforward and simple, but make sure that you do it. Take those extra steps so that you don't get accused of copyright infringement because your new product that just came on the market and you've put a bunch of effort and money into, suddenly the font that you used is infringing someone's copyright, and you end up getting shut down. Again, a little work at the beginning saves you a lot of grief and risk at the end. Next, trade secrets. Trade secrets are similar to patents, oftentimes. Oftentimes the subject of a trade secret could be patentable. The classic trade secret example, the Coke formulation. Okay. The Coke formulation has been secret for more than 100 years. Supposedly it's been, some chemists have come up with it, but the point is that the Coca-Cola companies kept that recipe secret forever. Now, had they put it out into a patent, for example, then it would have been public information, and once the patent term expired, then anyone could have been making Coke. The trade secret, the key to the trade secret, though, is that it is information that, one, is not generally known, it's a secret, and two, has competitive value to the company as a result of its being kept secret. So again, let's go with the simple example. The Coke recipe has significant value to Coca-Cola because no one else can make Coke, and no one can make it because they keep it secret. So it's the classic trade secret. Other common examples, sort of more day-to-day examples, include pricing, marketing strategies, other strategic plans, recipes, manufacturing processes for manufacturers, customer and client lists, and computer algorithms. Again, let's go back to that former employee. You've got a key salesperson. They decided to move on to the competitor. You want to make sure that that person does not take with them any customer lists, any client lists, any contact lists. Because if they do, obviously they leave you on Friday, they start on Monday, they're going to open up their Rolodex, they're going to open up their contact list on their phone, they're going to just jump right in and start taking your customers. So trade secrets, one, should be addressed in your employee handbook, and that's an important issue for the employment lawyers to address. But two, you have to make sure that you're keeping these secret. Public disclosure, for example, in a patent. Again, if the Coca-Cola company had disclosed the recipe in a patent, they could no longer enforce it as a trade secret because public disclosure is, of course, antithetical to being secret. So if you want the courts to treat your secret like a secret, then you need to keep it a secret. Don't tell people, limit the number of employees in the company who have access to the information. If the information has to go outside the company, or you have consultants who are involved, for example, with the manufacturing process, have them sign non-disclosure agreements. All of these types of efforts will show a court that you treated your information like a secret, so the court should treat it like a secret as well and stop someone else from using it who obtained it incorrectly, in some incorrect way. Trade secrets the courts will only enforce them for a period of time. We call it a head start period. In other words, how much of a head start would a person get by taking the information from you in some improper way, as opposed to just developing it on their own. So for example, let's go back to marketing materials or marketing strategy. Your head of marketing leaves the company. In his or her head, they've got all of the information for what your next 2 years of marketing is going to look like. They go to a competitor, or they think that they're going to go to a competitor. You can go to the court and ask them to stop that person from maybe working in that job, working for that competitor for a period of time, maybe as much as the full time of the strategy, maybe a little bit less, but the point is the court will look at the secret information, in this example, the marketing strategy for your company, say, well, if that former employee had just never worked for you, how long would it take for them to develop this all on their own? Very fact-intensive question, and the court is going to look at it in a very factual way, look at the industry, look at your company, look at the people at the company that the person is going to, but they will enjoin use of the information, stop the new company, the new employer from using the information for a period of time. Again, what we call a head start period. Domain names. Again, many times people don't think of a domain name as part of intellectual property, but it is an important part of your intellectual property. You don't want people, consumers, your consumers, folks you want to get to your website, you don't want them typing in a name close to yours. For example, a misspelling. And if they do that, you don't want them going to a competitor's website. You don't want them going to something maybe even less acceptable than a competitor out there on the internet. There are many, many websites out there that do this, that they take a famous or a well-known domain name and they register a close misspelling. And so that when consumers are looking for your company, they accidentally misspell it and they go to this other, be it a competitor or maybe something, again, a little more nefarious out there on the internet, and you don't want that. So what you need to do is take the time to register all of your trademarks as domain names, whatever it may be, but also get a little creative. Think of some misspellings. Ask your kids, ask your friends, how would you misspell my company name? How would you, here's my trademark, here's my new product that I'm putting out. Come up with some misspellings, register those as well. Because folks today go to their search engine or go just directly into the address bar of Explorer or whatever browser they're using, and they just type it in. And so if they're going to misspell it, they're going to go to an incorrect domain name. They're going to see a website that you don't want them to see because you wanted them to come to you. Take the time. It's an inexpensive process. It's a quick process. But what if you have a trademark out there and somebody, in fact, is squatting on it, what we call cyber squatting? They've taken one of your trademarks or a very similar trade word, something very similar to your trademark, and they have registered it so that folks are getting misdirected. Maybe you've gotten a call from a consumer or one of your employees saying, gee, I put your name, your trademark into my browser and I ended up at this other place that I didn't want to go. What do you do about it? Well, fortunately, the federal government instituted a law back in 1999 called the Anti-Cyber Squatting Consumer Protection Act, the ACPA. It has very, very strong and very good protections for exactly this situation. Because back then in the 90s, this was in fact happening. There were folks who would just grab up hundreds of domain names of trademarked, that covered trademarks, and they would sell them and ransom them out. So there are ways to deal with this. It's less frequent today than it used to be, but it is still potentially an issue, especially if you're going to come out with a new product. And by the way, circling back to the trademark issue, when you're thinking about a new name for your new product, your new company, whatever it is, your new service, go look at the domain names. What's available as part of your trademark search? There's no point developing a brand if you can't get the domain name today, because we all know your consumers are going to want to look at the website for your product. So make sure that domain names are part of your intellectual property discussion among your team. Again, my name is Kevin O'Shea. I appreciate your time today. Here's my contact information. I've given you a 500,000 foot level of each of these issues, and there's a lot more to it. Please feel free to contact me or any of my colleagues at Ice Miller. We will be more than happy to help you through, again, at the beginning or at the end if there is a dispute. Thank you again.